Hi, I'm DeAnn Chase, founder of Chase Law Group. I'm here today with our employment lawyer, Scott Liner. And today we're going to be talking about common pitfalls that we see business owners make in the employment context. So Scott, nice to see you.
Great to be here.
So let's talk about some of the common mistakes that you see as an employment lawyer business owners making.
Absolutely. So my practice, I'm regularly advising clients on wage and hour issues and all sorts of day-to-day employment related issues. And the most common problem that I see is that employers are misclassifying those people that they hire as independent contractors rather than employees. And there can be a number of reasons for this. Sometimes the person they're hiring just prefers it that way. Other times the employer just thinks it's easier that way and they don't want to bother with all sorts of things that come with employment. The problem is, especially in California, there are specific rules and requirements that must be met before you can even consider having someone being treated as an independent contractor. In California, there's what's commonly referred to as the ABC test. And in order for someone to be an independent contractor, they've got to meet all three of these factors. And one of them is that they're free from the control of the direction of the employer. And a lot of times,
that's A, right?
That's A, correct, yes. And a lot of times employers think they don't direct employees. I don't tell them what to do, but that's really not what they're asking for. They're asking for, do you give them a job to do? And do you kind of, tell them what's required for the job? And typically you almost always are for an employee who's working for your organization. Okay. The second thing is going to be, do they do the work that, and this is B, do they do the work that the business generally does? So, if you sell cars and this person is a salesperson or this person is involved in the selling of the cars, then they're absolutely going to be doing the business that you do. And then the third thing is whether or not they have a specialized field that they work in. For example, a bookkeeper, right? Or someone who works on IT. They have specialized skills that they do and they're performing that work. So
now, wait, is that but is that part C? Because isn't part C that so they're specialized, but they have to have their own independent business providing that same service that they're providing to the business owner to the public at large? Is that how that works?
Correct. Yes, they have to have their own business where they actually perform those services, those special services. So if they have their own business, but they're not performing those services for you, that's not going to count as meeting part C. So now there are some, first of all, you have to meet all three of those in order to be exempt from this rule. And then there are some specific exemptions to the ABC test. They can be professionals like lawyers and doctors and accountants. There also are certain jobs in the entertainment field and artistic field. And there's also a business to business relationship exemption. And we're not going to get too far into the weeds on that, but they're pretty limited. But even if those persons fall into those exceptions, they still have to meet another test, which is commonly referred to as the Borello test, which is based on a court decision a number of years ago. And this is a multi-factor test, which provides some more leniency in the analysis than the ABC test. But at the end of the day, it still is difficult to pass. The problem with misclassifying someone as an independent contractor is if you do so, you're subject to a lot of risk. One includes simply lawsuits filed by the employee where they're going to claim all sorts of wage and hour violations, whether it's failure to pay them in a manner that meets minimum wage for all the hours that they work, overtime violations, meal and rest period violations, as well as payroll violations. And this can be not only for the individual employee, it also can be on behalf of a class of people who work for you. So this can really amount to a lot of money ultimately, and it's simply not worth the hassle or the problem. So before you ever consider working with someone who's an independent contractor, it's really important that you consult with an employment attorney to make sure that you're meeting all the requirements.
Right. Okay. So apply ABC. You need all three parts to have an independent contractor. There are some exemptions. They're limited. And in those circumstances, we're applying quite often that Borello test, which was actually that was the original test before the ABC test.
Exactly.
But it still applies in a lot of circumstances.
Correct. Yep.
Right. So a lot of risk there, definitely, in hiring independent contractors is a common pitfall that we see.
Another pitfall that we see is where employers treat non-exempt employees as exempt employees.
So what does that mean when you're saying exempt versus non-exempt? Exempt from what?
exempt from all of the wage and hour requirements, such as paying overtime, meal and rest periods. Those are the big three, and requiring pay stubs, but that requires whether you're exempt or non-exempt, that applies. So the significance of that is a lot of times employers think, well, I pay someone a salary, right? So they must be exempt. Well, first of all, salary is just one part of the test as it relates to exemptions. So again, all employees in California are deemed to be non-exempt unless they meet certain exemptions. And the California legislation has set up certain specific exemptions. For example, there's a professional exemption or learned professional exemption. That's, again, doctors and lawyers and accountants and the like. There's also an executive exemption. These are people who run either the organization or a subunit of the organization, and they also supervise at least 2 employees most of the time, and they use their independent discretion in performing their job duties. And the third, which is kind of a catch-all, is the administrative exemption. And this one is the one where there's a lot of times is risky for employers to do, but basically if the person is performing certain job duties independently that relate to the business operations, they could meet that exemption. But if you don't meet those exemptions, but you're treating someone as exempt, then you're exposed to, again, violations. And these violations can be penalties, including rest period, meal period violations, as well as overtime and the like. The second piece of all these exemptions is that these employees have to also be paid at least $68,640 annually in salary. And a salary is just
Not
that.
exempt.
To be exempt, you have to be paid
exempt,
salary. Correct. You have to be paid a salary of that amount in order to be exempt. And you can't apply commissions to that amount because it has to be a regular, consistent salary. So you can't, if someone receives draws generally don't apply to that compensation. So it really just has to be a regularly paid salary. And if they don't do that and they don't pay and treat someone as non-exempt when they really are, they're subject to all those penalties that I mentioned.
Got it. So it's really risky. We see that a lot too, is everybody's like, oh, I'm just going to pay them a salary so that way I don't have to keep track of their hours. But that's really risky unless they fall within one of those exemptions and meet the salary requirement. Otherwise, I think as a default, it's always best, if in doubt, pay them as a non-exempt hourly employee, but be sure to track their time.
Correct. And they can consult with an attorney, experienced employment attorney, to see if they'd like to treat the individual as an exempt employee. And we can go through that analysis and see whether or not they meet the exemption. It's very important.
Yeah, make sure definitely before they hire someone in that capacity.
Exactly. The next common pitfall that we see is where employers don't make sure that time worked by the employees is accurately recorded. And what I mean by that is that employers are required to pay employees for all the work that they perform. So in order to make sure that all of that time is captured and that we have a record of it, employers should use some kind of timekeeping mechanism. Ideally, it would be a time card or some software on their computer. I suppose they could write it down if necessary, but in this day and age, I think the use of technology would be the best way to do it. And employees should be told they record and start recording their time when they start working, not before they start working, and the same at the end of the day, as well as for when they start and when they end their meal breaks. This way, at least you have a record of when they recorded their time and when they didn't, and also making sure that they took their meal break, because it has to be a 30-minute uninterrupted meal break. And that means that if, for example, they're in the back and someone walks into the store and they come out and deal with that person, interact during their meal break, that's an uninterrupted meal break. And when that happens, that's okay, but you have to pay what's called a penalty of 1 hour of their wages for that interrupted meal break. So again, the key here is that you have a record as an employer as to the hours that the employees worked, so that if later on they were to claim that they worked more hours or beyond what you paid them, you say, no, here you clocked in, here you clocked out, and you have some kind of record for it.
So, and the burden is definitely on the employer to track the time, right?
Right.
And so they get a 10-minute rest break. Is it the first 4, if they work 4 hours, and then they get a 30-minute uninterrupted meal break, and then in the next, if they work another 4 hours, it's another 10 minutes or something like that? How does that? How does that
Correct.
date
Mostly
progress?
so. So employees are entitled to a 10-minute rest break for every 4 hours that they work or major fraction thereof. Basically, employees aren't entitled to a rest break unless they work at least 3.5 hours. But if they work like 6.5 hours, then they'd be entitled to 2 rest breaks.
Okay. And it's very spread out. It's very time sensitive.
Very
So
specific.
again, it's really good to make sure that they clarify that. And then do they have the employee clock out for the 10-minute rest break?
No, that's not necessary to do. I mean, you can do that. The meal break is the most important thing. With rest breaks, as long as they're given an opportunity to take the rest break, it's not necessary that they actually record it. But you can, out of an abundance of caution, if you wanted them to, you certainly can have them do that. And on the meal break, you mentioned also, once an employee works up to 5 hours, that's when they are entitled to a meal break. And then that meal break, as best as possible, should be at a time where, one, you got to stagger them, right? If you need people to be working at different times to make sure that. And similar with rest breaks, you don't want everybody taking breaks at the same time. And also, though, it should be kind of done in the middle of the 4-hour period of time, but you're going to have to also stagger that. So that's something that the manager or supervisor just needs to be keeping in mind when people are taking their breaks, and to make sure and tracking that they're taking them at the right time.
Right. Yeah, definitely. I mean, I think sometimes, the employer, you want to keep the employees happy and, you want to be like that nice guy. But like a common thing that we see is that an employee says, oh, I'm going to skip my lunch and leave early. And that's a no-no. Right. So they're very time sensitive. They have to be taken at very specific times.
Exactly. A lot of risks otherwise, again, with all sorts of wage and hour violations and penalties that can lead to costly lawsuits.
Got it.
Another common pitfall that we see is when employers don't take the proactive step to review time records of employees. So this is significant because whether it's each payroll period or once a month, an employer can go back and see, making sure the employee took their 30-minute break. Did they work overtime or not? And by doing this, you can avoid violations, find violations, and also there's some new Private Attorney General Act, or PAGA, laws that came into effect last year that allow employers to reduce the violations if a claim is made, if they took these proactive measures and they did periodically check to see if there were violations. So it's a good thing to do in practice, not only just to have these rules, whether it's in your employee handbook or in other policies, but otherwise to periodically check the time records and see whether or not, A, people actually work the time that they claim. Maybe they were not there and someone recorded their time for them, God forbid, or more concerning or difficult as far as violations go, that they didn't work beyond the time that they're supposed to, beyond 8 hours in a day, or that they did in fact take a full 30 minutes for their meal break. And sometimes, and if you see that, you can talk to the employee and say, hey, I see that you took more or you took less, and maybe they say, oh, actually, no, I did. I recorded that wrong. And they just got to get something in writing from them that says that, in fact, they did work. I did take the full break. There's ways you can address that. But that's why we're here, to answer any questions if they have any problems.
Well, and we are here definitely to answer any questions. I think that's the important thing. I mean, we want people, business owners, to know high level, what they need to be kind of aware of. And again, these are just common pitfalls that we see. But really, in every instance, when they're structuring an employment program, it really helps to talk with an employment attorney, such as you, to make sure they're doing it right. So I think that if anyone who is watching our video here and they want more information, they can just reach out to us at the website and ask for a consultation. Or just send us a direct message and we can set up a time where they can speak to you directly. So thank you, Scott, for being here today for Employers Corner. I appreciate it. And it really helps to talk over sort of some of the things that we see every day.
My pleasure. Great to be here.